Oh yeah. There's no reason to prove. Welcome to the Aviator Squad. We shooting the camera light on the incident. Heard you in trouble, you about to frown. Boy, you gonna face the crime. We're gonna talk about the law and all those involved with the bar. What you think you know about it? You heard of the Knights Templar. What you think you know about it? This is the show, the Aviator Squad. We're gonna put a camera on some lights. You understand what I'm saying? We're gonna take a look, see to what they doing. All y'all young lawyers out there. Who you work for? Who owns the bar? Who prescribes your license to legislate? All the judges. Y'all know what I'm talking about. It's your boy, Digital Pit Boss, baby. We just the third day into the new year, and I'm already making trouble. We had to move a little bit bigger than the unconscious community. They just don't know what they talk about. We got to go a little bit deeper. Welcome to the show. Y'all know how we do it. Yeah, we back. We back for another one. We back for a hydraulic hot one. Better get on it. I'm going in today. This ain't for you. You know, if you ain't really into thinking, this show probably not for you. If you don't like being put under stress with critical thinking, this show is probably not for you. What up to all the calculated risk takers? Appreciate you for supporting the channel. Because I ain't coming here if I don't get over it. You know what I'm talking about. What up, GG? Oh yeah, I'm in the mood. I don't know, this video ain't gonna be too long. It might be an hour. I got some audio for you. I got some video for you. We're gonna read a few pages. We're gonna get into it. Y'all read the title, The Crown, the Bar, Law, Knights, Templar, Money, Economic Slaves. I know how many economic slaves is out there. Which one of you are not an economic slave? Which one? You? Stop lying. You can't wait to get to work tomorrow so you don't get fired. I know how I get down. Be like, you know, I work for myself. You got a license. Somebody told you could work for yourself. Yeah, that's what's happening. Oh, I'm about to crack some heads. Y'all ain't gonna you ain't gonna get this over there at the where all those other YouTube channels. Now there's some YouTube channels out there going in, you know, some of the video come up off some of them channels and blah 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 blah. But we're gonna check it out. So the first thing that we got to understand here, everybody has been involved with the law. Everybody. I know one body, somebody, one person, not body. Everybody, even the God body, baby. You've been in the law. You done sat on before the bench. And you have had legalities spoken upon your interests. Yes, sir. Dealing with it. We over here on this no, we on some cucumber water. Because you know, if I don't drink this water, keep the mind working, I won't be accurate. Because I got little people out there called jabbing BB gun pellets trying to blast at me from a dodge. Then I got these crazy broads running, throwing lyrical javelins at me. I just get that. You can't mess with the pit boss. Is you crazy? You don't know nothing. Oh, look at this math guy. Oh, math guy, I got analyzers in the room. Pimpin', you got 7 subscribers. You better be gone. Paul's put them on you, baby. We over here with the technology. We getting all in y'all isnizzle. Better chill back, man. Sit back and enjoy this one. This one is talking about law, money, economic slaves. It's talking about you. You know what I'm talking about. All right. Let me overlook these drones in the goddamn room. Get to this business, right? So first thing I want to do. We're going to read a little narrative. You know, this is just a little something, just to give you a little context of where our law is originating from. Now, some say that the Bible put us in slavery. Yeah, right. All right. Why I don't preach that? Well, here's why. Back in the day, way back in the day, there was such a thing called the Roman Empire. And the leader, Julius Caesar, well, he didn't believe in no Bible. About no Bible. He wanted to talk about money, power, and respect. Put his knee on your neck. Yes, sir. They wasn't dealing with no Bible. Matter of fact, they was dealing with a paganistic system that they called the Roman mythology. But we ain't talking mythology right now. We talking about law. So what did they do? They had an institution. They taxed the people. They legislated law in Rome. That's what they did. Was ruling. Okay, so we got them, right? And so they create this law system. They operating whatever. They killing these people and conquering these people and blase, blase, blase. Then, roughly around 381, Rome breaks in half. One to the east, one to the west. Well, the Western Rome, they were just completely annihilated. They just dribbled down into history as statues. They just turned into statues, right? But the other half, the Eastern Rome, well, the Eastern Rome, shit, they still had their shit together. They cracked off and changed the name and played a different game. Want to be way out? Yeah. They turned it to the Byzantine Empire. Now, obviously, they could see that a Christian system had overtaken their paganistic Roman ideology, and they switched game up, and they started adding in all kinds of crazy madness, right? Created the Catholic system. They put the temple over there in Rome, call it the Vatican. And there they would dispense justice, religion, spirituality, wickedness. Everything is about to move according to the Byzantine Empire, right? Roughly around 400 AD, 450. Who cares? We ain't really worried about the dates right now. This is just the ground foundation of some information to get you back to the 2016 law that you sitting as an economic slave under and not knowing what the hell is going on. Why they treat me so bad. So they start marching all over the damn place, whipping up everybody, beating on everybody. Then we get to like the 11th century, right? And guess what? The Muslims had been reigning for a while. They had this prophet. His name was Muhammad, peace be upon him. As they say, peace be upon Prophet Muhammad. And the Prophet Muhammad, he wasn't playing that. He put an elbow on them white folks. Said, back up, nothing around here go down. He was holding it down for a little while. Had the white folks running crazy. But what did they do? They went back and started thinking what you're thinking they thinking and started calculating the risk. Yeah, they started calculating the risk. So in 1099, that calculated bet came through. So I'll read you a little bit of narrative. This is the rise of the Europeans in the Knights Templar. It says, after the Europeans in the First Crusade recovered Jerusalem in 1099, many Europeans made a pilgrimage to various sacred sites in the Holy Land. Although the city of Jerusalem was under relatively secure European control, the rest of the outermere was not. Bandits, marauders, highwaymen, they preyed upon the Europeans making their transition from Europe down into Jerusalem. They wanted to see what the church looked like. They wanted to see what the ruins looked like. They had already got it from the Muslims who had gained a little bar hold on it, right? So those marauders and those bandits, they was laying in the cut, waiting on these Europeans to walk on through. And they would routinely slaughter them. Give me yours. Sometimes one or two, sometimes about hundreds. As they was making a journey from the coastal lines at Jafar. Y'all go Google that, Jafar. Into the interior of the Holy Lands. Now, because of all of this slaughter, you know, the white folks was like, damn, we getting slaughtered out there. So a group of them got together and they called themselves the Knights Templars, right? Over about 100 years, they started to formulate, not even 100. I'm way off. About 20 years in the game. They started to get their act together. They created this group of Europeans, called themselves the Knights Templar. Now they had a version of Christianity. It ain't the Christianity you working with, if you're working with it, or it ain't the Christianity that you ran away from when you ran over there to Kemet. But nevertheless, this is what they was doing in 1119. The French Knight Hughes de Payen approached the king, Baldwin II of Jerusalem. He was running things. And a warm patriot of Jerusalem, and proposed creating a monastic order for protecting these Europeans that was smashing in through the country. So King Baldwin agreed to the request at the Council of Naples in January in 1120, and the king granted the Templar a headquarters in the wing of the royal palace on the Temple Mount. Now this temple, they flipped the name. They started calling this temple the King Solomon's temple. They had the biblical narrative all screwed up. But nevertheless, they was in control, so they could do what they want. Now prior to that, it was controlled by the Muslims. Muslims had a lock on the spot. And they wanted the spot back. Now, back when the Muslims had it, it was called Al-Aqsa Mosque. It was a mosque. Same building, different name. Name change, people change. Want to live your life high. Same song, can't go wrong if you play the nice guy. Y'all heard about Pac, right? He was kicking it. So check it out. In the Temple Mount, they had a mosque. Hold up. Let me look. Okay. So, in this temple, which was a mosque that turned into the temple, they had these crusaders. They were referred to as the Al Mosque and the Solomon's Temple. And from the location of the new order took the name Poor Knights of the Christ and the Temple of Solomon, or the Templar Knights. They were in order, with about 9 knights, including Godfrey de Saint-Omer and Andre de Montfort. They had a few financial resources and relied on donations to survive. They needed that AdSense. They needed some AdSense. Y'all know how it goes. Sometimes you just need a little help. Poor righteous teachers. You know what I'm talking about? So, now they had an emblem, right? Just like we got an emblem. They had an emblem. It was like 2 knights riding on a single horse, emphasizing the order of poverty. They ain't got enough horses. Right? So now with this little poor thing, they went out there and started defending the Europeans coming through the land. On the bandits that was smashing on the pilgrims, back and forth, back and forth. And they was like some brave-hearted white boys kicking in the door, waving the fofo. They was getting to it. So as they started to build, their reputation started to build, right? So they was like, well, you know, we got a couple of guys out there banging on the beast. And so as they was banging on the beast coming in, you know what I'm saying? They said, let's fund them so they could be well prepared for battle. And so all this money started to pour into the Knights Templars, right? I mean, they gave them a building, an office, troops of horses, spears, whatever of the time, they had it. They was walking around. They was the shiz nizzle. You understand what I'm saying? They was the shiz nizzle. And somebody always like to text me while I'm doing my show. I can't understand it, but back to the show. Y'all know how it goes. So now check it. So with the money, that shit started stacking up. They was like, boy, this is better than hustling. Money just coming in, because see, with all of the travelers coming there, the travelers are spinning bread. It's economics growing. This was like recorded history of one of the first examples. Now, it could have been done before, but here we got it on record that they had a multinational trading operation. Global trade was going on. They was coming from Europe, traveling all the way to Jerusalem, passing by way through Kemet, working their way on down the Red Sea, back up that way. They come in through Turkey. They didn't care how they got there as long as we get there. And they was on their way. So with so much activity and so much bread, the bread just started stacking up. And the Knight Templars was on it. They became one of the richest groups of people over time, right? This is the story. Go Google it. It's got a little pit boss twist on it because y'all got to stay awake. Y'all don't work it out if I don't put it down in such a way that you tune on in. So now with this, they decided we got a lot of money. We got a shitload of money. So they made what you call a bank. They started stacking all that bank in the bank. Now here's the thing. So that the Knights didn't get a big head, they took an oath not to really have any worldly possessions. They didn't want to be walking around with gold tennis shoes on and matching belts from some, you know what I'm saying, European designer. So they kept it simple, strict to the code. They was warriors. Yeah, but that money just kept on piling up. So there's the thing. Let's get down to the business. So although the primary mission of the order was military, relatively few members were combatants. The others acted in support positions to assist the Knights and to manage the financial infrastructure. The Templar order, through its members, were sworn into individual poverty and was given control over wealth beyond direct donations. A nobleman who was interested in participating in the Crusades might have all his assist under the Templar management while he was away, accumulating wealth in this manner throughout Christendom. The order in 1150 began generating letters of credit for the Europeans journeying to the Holy Land. And the Europeans, despite their valuables with the local Templars, precipitator before embarking and receiving a document indicating the value of their deposit. So here's what they would do. When they was in Europe, they would say, I'm going to the Holy Land. I'm going to spend about a year out there. He got a big fat bankroll. He would walk into a banking establishment and they would write what is called a check. This is a check for what you just checked in. I say, okay, you know what I'm saying? Gigi just walked up in here with 10,000, ballin'. And they would just go ahead and give her a check for 10,000. Put the stamp of approval on that. Made it official. They said, take this with you. When you get down there to Jerusalem, go over there to the Knights Templar and give them this check. And when they see the official stamp, they'll give you 10,000. That way, the bandits and the robbers along the way, they don't rob you. You ain't got a whole lot of money. Boom! Banking institution was created. So in reality, they started off as like broader, noble Europeans. They ended up a bank, world institution. Now, from this order, shit gets a little crazy. Shit starts to turn into American law. So, let's share a little something with you. Let's share a little something with you. Y'all paying attention? Is y'all paying attention? Okay, let me share my screen. So now we just gonna get into one quick paragraph here. I gotta lay this down. So originally, the soul or the court was the Curia Regis, one of the three central administrating bodies along with the Exchange and the Chancery, from the Court of Chancery formed. This Curia was the king's court. Remember that word, king's court. It's relative to law. It composed of those advisors and courtiers who followed the king as he traveled around the country. This was not a deducted court of law. This was not an actual court where, God damn it, you go get sentenced, but they was operating a form of law. Instead, the descendants of the Widemont, in concert with the Corsia Regis, the Eri Circus, staffed by an itinerant judges, dispensed justice throughout the country, operating on fixed paths and certain times. These judges were also members of the Curia and would hear cases on the king's behalf in the lesser Curia Regis. Because of the Curias traveled with the king, it caused problems with the dispensation of justice. If the king went out the country, or had Richard I spent much of his career there, the Curia followed. The remedy to this a central bench. Now, write that word down, bench, because when you go before the judges of the king, you will stand before the bench. Just as the men did at this particular time, way back when black folks were still in the jungles, operating E5, getting with the magic dust. White folks was over here creating law. They was working their way on to slavery in a few hundred more years. They couldn't wait. Money calls, money never sleep. So it was established with the Court of Commons Pleas, initially split from the Exchequer of Pleas, receiving official recognition by the Magna Carta. Y'all know about the Magna Carta. Go ask Jay-Z. So that common pleas could be heard in some fixed places. There were thus two common law courts, the Curia, which followed the king, and the common pleas, which sat at Westminster Hall. And the Curia eventually became known as the King's Bench or the King's Court, with the king himself acquired for the court to set. Now y'all know what we're going to, right? Now that's just to get started, right? Because I'm setting up a bomb. Y'all just not understanding. We getting to the bomb. You know how you go get a law degree and you know what I'm saying, you want to go in here and defend somebody. You want to help justice. You want to bring justice. But you're going to need a license if you want to bring justice. And somebody got to somebody got to own that bar. Because there ain't a business operation in this country that you ain't got to file for. Can't be operating business and you ain't got your legalities in order. But it's funny. It's very difficult to find out who owns the bar. It's mystical things about it. Some think that the Queen of England owns it. She just laughing at y'all. She's like, I don't own that shit. If I own that shit, damn it, y'all send me my money. Where my money? Run me my money. That's what she be like. She had nothing to do with the Knights Templar. There was a band of bandits. We get into how the Knights Templar operating the operations of the Europeans traveling to Jerusalem and banking all that money from the people paying all that ass in, throwing in their donations, building up the banking institution that would come to be in the modern age. But first we got this build up. So after the era of these Templar Knights, right? I think we got a little more to go. Got a little more to go, right? So after the order of the Knights Templar, it kind of came to an end. That was not so. Shit started building all this money. People was doing things. They taken the framework of the king's court, something that they was used to in their history. This is how things work. The king has his court justice. You know how that little clown dude with the funny little hat and the balls? He was the court justice. Yes, the court justice. You go in the court to get justice. All this shit makes sense. You better read your fairy tales. You better pay attention to your fairy tales because your fairy tales tell tales. You better pay attention. So those justices and that system of the Knights Templar, after the era of the Knights Templar was over, something formed and landed in Britain. They built some hotels for people to house themselves. A distinguished group went over there. They were called barristers. Their interest was to study law. Yeah, barristers. Remember the word bar, because the word bar is short for barrister. So now, the barristers are learning law. They are going before the king's court. And so they stand before the bench because the king is a judge. Oh, this shit get deep. Y'all already know this stuff, but who cares? You ain't never heard it this way. So the king's court and the bench and the barrister. You also have a solicitor. Now the solicitor, he doesn't have the right to necessarily speak in the operation of the court. He could deal with the public. But the barrister, he don't deal with the public. He deals with the king of the court, the judge. So they had this system. It was in early stages and it was formulating and formulating. So the place that they live, you know how you got a hotel and then you got a Holiday Inn? You say your hotel, your motels and your Holiday Inns. Well, they had what was called the 4 Inns. Let's get to those 4 Inns. Oh yeah, this shit get deeper. The more you go to sleeper, the colder it get deeper. Now, in this 4 Inns, there were 4 types. The Honorable Society of the Lincoln's Inn, the Honorable Society of the Inner Temple, the Honorable Society of the Middle Temple, and the Honorable Society of the Gray's Inn. Let's take a look at the logo. What you know so. You see that? I do logos for a living. So more than what you're looking at is just the logo. These are the 4 Inns comprised within the Inns courts. The school, Inns of Court of Law. This is your early framework of American law. These are those guys. Prior to the formation of your American law, you had this. Now, each one is the emblems. You got a horse with wings, the Pegasus, and the eagle with wings. And you have the cross with the cow. What the hell? Anyway, then you have the lion. The colors, everything symbolic. Nothing about a logo is non-symbolic. Everything is symbolic. You got to study it to understand. So, let's get back to business. Y'all do further research because I don't have time in these videos to get super detailed unless I'm just going to narrate right into a specific thing. So I just gave you the 4 Inns. You can find them and do more research and understand the differences of the Inns and how they play their part, depending if you're in the Lincoln Inn or the Gray's Inn or the Inter Inn or the Middle Inn. It is all relative to law. Now, it gets a little deeper. Shit gets a little deeper. It goes a little deeper than that. All right? So let's give a little narrative. So the longest surviving and most informative of the record series are the council minutes, those for the Lincoln's Inn, known as the Black Book. Hold on and be strong. Hold on and be strong. Because when it's on, it's on. This book, I didn't show this book before. This book is better than the book you got if you don't got this book. This book tells you how to speak English in a courtroom. If you don't know the definitions of this book, you ain't even talking English in the courtroom. They don't know what you're talking about. They call you a monster. Go ask Nellie Fuller about a monster and what a monster is. You're a monster in the court. You're such an obese, ugly thing to speak. Shut up. You don't know what you're talking about. And they bring before you an attorney. Now, every word is specific because an attorney is not a lawyer. Yeah, I said it. Yeah, I said it. An attorney is not a lawyer. And a lawyer, he's not an attorney. Anyway, they look the same. Both of them get a fat check. Everybody except you. You know why? Because you're the product. Oh yeah, this shit get deeper. You think I'm done? We ain't got started. We got a good 30 more minutes. Now, back to the subject at hand. So, those for the Lincoln Inn, known as the Black Books, run in a continuous series from 1422 to the present and have been calendared until 1914, with a new volume coming forth. The other Inns have parallel series known as Acts of Parliament in the Inner and the Middle Temple, and pensions books in the Gray's Inn, which date from the 16th century. These have been calendared up to the 18th century. Between them, these minutes provide a fascinating insight into the lives of the Inns over the centuries and their reactions to the political and religious upheavals of the past. The papers set before the councils include petitions and anecdotes, agendas. The Lincoln Inn, known as the Blue Jackets because of the color of their wrapping. Y'all remember the logo, right? Yeah, the one with the blue in the back. That's the Lincoln's Inn. Flesh out something bare bones of the formal record. Between the parliaments, in the temples held less formal meetings of the bench tables at which orders could be passed. The series of bench tables orders commencing in 1666. A mascot just came in. She runs my errands. The bench table assumed the greater significance in running of the ends than the more occasional meetings of the parliament, and it is this series which takes over from the acts of parliament as the main formal records. Those are court document papers. This is how you build civil law, case law. Every time something happens, they write it down. They make judgment, judge rules, rule becomes law in the court. All this shit made up. None of this shit approved by the people. None of this approved by we the people. This was going on way before we the people. That's right. It was a hostile takeover. It was a very hostile takeover. Yeah. You have been bamboozled long before you was ever known. Long before you was known, you was bamboozled. So now, I see some people trying to reach for straws. Y'all way off. I'm trying to tell you, Pitbull, stay in the game way past what you're talking about. All right. So we back to those Knights Templars. They're the beginning of this. Because, see, law is not really about legalities. It's about money, honey. If it ain't no money, you ain't getting no honey. That's what she told me. I said, well, get on. You know what I'm talking about. Okay, so let's go back a little bit. Let me take you back a little bit. Go back to these Knight Templars. It says, in these castles, which were both monastery and cavalry barracks, the life of the Templars was full of contrast. A contemporary describes as the Templar as in turned lions of war and lambs at the heart, rough knights on the battlefield, pompous monks in the chapels, formidable to the enemies of Christ, gentleness itself towards his friend. Having renounced all the pleasures of life, they faced death with the proud indifference. They were the first to attack and the last to retreat. They were the first to attack and the last to retreat, always docile to the voice of their leaders. The discipline of the monks being added to the discipline of the soldiers. As an army, they were never very numerous. A contemporary tells us that there were 400 knights in Jerusalem at the zenith of their prosperity. He does not give the number of the sergeants, who were more than numerous, but it was picked by the body of the men who, by their noble example, inspirited the remaining of the Christian forces. They was operating some paganistic opportunities because ain't nowhere in the Bible told no Christians to go seize Jerusalem. That just ain't in there. They making shit up. They giving shit a bad name. Nevertheless, they about that money, honey. Give me that bread, Fred. They were thus the terrors of the Mohammedans. Who are the Mohammedans? They were terrorizing the Mohammedans. The Mohammedans had already came over here. Wasn't nobody over here. Last time they looked, the Jews had got slaughtered and ran off. And it was just a barren wasteland. So they moved on in, trying to resuscitate the flow. Correct the narrative, since these so-called Christians, them old Christians, running around with the remixed Bible, messing shit up, giving shit a bad name. Nevertheless, this is what was going on in Jerusalem around 1264. So the Mohammedans, they were defeated, and it was upon them that the victory vented his fury. And the more as they were forbidden to offer ransom. When taken prisoners, they scornfully refused the freedom and offered them on the condition of apostasy. At the siege of the Safed in 1264, at which 90 Templars met death, 80 others were taken prisoner and, refusing to deny Christ, died martyrs to the faith. The fidelity cost them dear, and it has been computed that in less than 2 centuries, almost 20,000 Templar knights and surgeons perished in war. Now, why did they perish in war? Because the shit they was doing was all made up and God wasn't with it. Shit was wicked. And thus, they met their end. Shit was over. But that money was still buried in that bank. Now what you think? Now what you think? That money was still buried in that bank. What it do? Moon taking Whitaker. Welcome to the show. I'm still flowing. I got to stay out that chat box. Y'all be out there burpulating in the chat box. Y'all just be in the chat box burpulating. All right, so check it out. I want to show you something interesting. I want to show you something. Just sit back. I want to show you something. So what we have here, right? Now what you're seeing here, this is the Federal Reserve. Let me make sure I'm on the right picture before I just get to saying something. No, this ain't the Federal Reserve. Okay. So this one here is the federal court. This is where they sit and judge what's going to be correct in law as cases make it to the federal court judges. Now take a close look and ask yourself, what does that look like? Most of y'all think that looked like Rome. Some of y'all smart enough to say Greek. But the reality is this was all taken from Egypt. This is Egyptian, stolen by the Greeks, then stolen by the Romans. And this is where they hold law. This is what you call the court, the king's court. King Court's justice, there are 9 of them. 9 court justices. That's what they call them, the court justices. All of these things are symbolic of an older system that was operating before America, that they are duplicating. But here's where the twist comes in. This is a court. Righteous. This is a court. Now this, you see the pillars? Matter of fact, let's go down to this one. Not good enough. Uh-oh. Hold on, be strong. Because when it's on, it's on. Hold on and be strong. Because when it's on, it's on. Now, you see the pillars? The pillars are still there. It still looks like Rome. It still looks like Greece. It still looks like Kemet. Guess what, though? This is not a court. This is a bank. That's what I said. This is a bank, and it looks like a court. And then it looks like a bank. Because inside is where they keep that bank. That's where they keep that currency. So when you start dealing with a federal level of things, they got money to spend. So they go all out. And they build these magnificent buildings all over the country. And you can't tell the difference between a court and a bank. Because this deals with currency. Well, when you walk in a courtroom, they're dealing with currency. They're dealing with the court. Now, there was a man, you guys should have known of him long ago. You should have known of him long ago. He came through. He was scapegoated. He was considered a conspiracy theorist. He had all kinds of stuff. A white boy, matter of fact. He's still around. He over there on Alex Jones doing interviews. His name is Jordan Maxwell. He said that the police is tapping his phone and aliens is coming to town. He got all kind of shit he talking about. You can't tell the truth from the fiction sometimes, but once in a while, he drops a bomb on you, baby. So let's take a listen to Jordan Maxwell. Now I'm going to show you this video because I think we can get away with it since one of them House of Conscious Negroes don't own it, right? We can get away with it. That ain't the one we want. This the one we want. All right. Let's kick it into action. Y'all just sit back. Let me rock this boat. Let me rock this boat.
All over the world, all governments are ruled by what is called civil law. Civil law goes back to a Latin word, civili, which goes back to the word illy. Oh God, we can go on for hours on this stuff. Civil law, which is called in all countries the law of the land. So you say, well, you can't do that because it's against the law of the land. The law of the land is civil law, Roman civil law, the law of the land. But there is a second law which also operates all over the earth identical. It's called UCC, Uniform Commercial Code. That is the law of God in the world of business. I don't care if you're in Japan, in Africa, in China, and Istanbul, Turkey. If you have a company, if you have a corporation, if you are doing business where you buy and sell and make money, you are operating on this earth under something called UCC, Uniform Commercial Code. Because if all countries work on a different commercial code, then nobody could do business with anybody.
Boom. If y'all work separately, you can't do business with nobody. So if you're a black nationalist and you nationalize yourself, you still got to do business with the beast that you banging on, SETI. You still got to do business with the beast because you ain't going to control the whole globe. Oh, no, no, no. And since you don't understand what real nationalism is, having economic control of your environment so that you may do business with others who got economic control of their environment. And that's what you call globalism. And we rocking, we still smashing, we still pumping fraternal order of Pan-Africanism. Salute. Y'all ain't never heard it to the truth. But I'm going to bring it in the dough because I'm not done. Not a bit, not a bit. I'm not done. We still got 15 minutes to go. I'm timing this one. I got something else coming for y'all later on. It's going to be presented by someone else. Yeah, I'm working for you. Support the channel or I'm going to go away. Now, we heard about the Knights Templar. We know about the 4 Ns. The 4 Ns have barristers. Barristers is the low word for the bar. The bar became the American Bar Association, where all the citizens of America go to learn law so that they can run in and represent you, the monster, described to us by Nellie Fuller, that you are just a monstrosity. Look it up. You're a monstrosity. You're about the ugliest thing I've ever seen. Anyway, though, the game gets colder, right? So now, I'm going to have to share the screen with you guys again. Because, you know, sometimes you need to read. Just sitting back on your couch potato thinking you're going to get it ain't going to cut it. We just go into some simple Wikipedia because we're dealing with simple subjects. Some shit that y'all ain't going to bicker and beef about while I hit you in the mouth. We're just dealing with the simple bank. It's a financial institution that accepts deposits from the public and creates credit. Lending activities can be formed either directly or indirectly through capital market. Very basic understanding. A bank. You remember the picture of the federal bank, right? And you remember the picture of the federal court, right? The word, this now we dealing with the bench. In legal context simply means the location in a courtroom where judges sit, the federal court. This is a historical root meaning that comes from judges formerly having sat on long seats or benches. That's what they say on Wikipedia, huh? It's all good. Sometimes you got to have the sleight of hand because they're programming drones, human drones. So the word also has broader meaning in law. The term bench is a metonym. That's a good word, metonym. Used to describe members of the judiciary collectively or the judges of a particular court, such as the Queen's Bench or the Common Bench in England and Wales, or the federal bitch in the United States. That's the one we're looking for. The term is also used when all judges of a certain court sit together to decide a case, as in a phrase, before the full bench, also called the en banc. The en banc, the bank. Yes, sir. The judge sits on a bank, and you come before the bench to make a deposit. We call that putting your ass in a cell, or we gonna give your ass credit, and you could bail out of jail because I heard you was driving a Pinto on the highway of hell, and you ended up in front of the court asking for bail. You know how you gotta go see your probationary period before you can be free. Mr. I'm a guard, but you're gonna go see your probation officer, right? Oh yeah, you're gonna go see him because you're gonna learn today. You're gonna learn today. So now all of this has its root. All this has its root. This shit get deeper. This shit get deeper. I'm just touching surface shit that you know. I'm touching surface shit you already know. You know all these things separate from connected dots. You see a here, you see a there, but you don't connect the dot, but you know about it. You heard of this, you heard of that, but you don't think about it. You're just easily going along in your migrational path on your way to your integrational mansion that you just can't wait to buy. So you could be in debt forever. When you finally pay it off, you still got taxes. Unlimited taxes forever. Miss those taxes, and guess what? You're going to have to see the IRS. The IRS is going to call in the sheriff. The sheriff is going to show up at the door, and he's going to put a little pink slip on your shit. By that time, you out of money. Now all your shit sitting in the front yard. Everybody sees your ish. Y'all know what I'm talking about. Eviction time. Eminent domain. You was a slave all along. You thought you had it in the bank when you dropped that platinum, didn't you? But 150 years later, you couldn't pay the rent on your own mansion, on your own mansion. So, with all these connections and the dots, once you learn this book and every word in it, when you learn this book, forget the goddamn Necha for a minute. We understand you want to learn that shit. Get this book. And when you learn this book, I'm going to show you what you could do. Y'all take a look at the Digital Pit Boss logo for a minute, though. You understand what I'm saying? Holla at the logo. What up, CRTs? Y'all in the building, raise up. Now, what you're about to experience is a legal lesson in law by somebody who owned the book. So this video is roughly about 5 minutes. It's longer, but I'm only going to let it play about 5 minutes. Give you the context of the workings and the understanding when you understand the unified system of law. When you know how to navigate the currency, when you know how to navigate the waters, when you know how to navigate the water, you are able to arrive at the destination and pull into the birth. Better have a manifesto when you get there. So check it out.
I really do not wish to have to continue coming here. Each time I come here, I'm threatened and told that if I don't show up, then people...
I would imagine that they can take the kids in if you get the paperwork filled out. What I'm saying is that there's paperwork, we'll give you the forms, you can just sell them or work on them. If we can take them here after we've gone through all of that, and take the play, I'll take the play. Otherwise, we'll send you upstairs.
Am I entitled to responses to clarifications that I have regarding the cause and nature of these proceedings?
I've told you what the proceeding is. You have been arraigned.
Objection. I have not been arraigned at this point, and
No, our records show that you have. All that arraignment is that you get an order is when you next appear, and you get given the accusatory instrument, which reflects that you did. So that's arraignment.
Has the prosecutor submitted evidence establishing jurisdiction?
There is no. That's not the part of the proceedings. That's not arraignment.
Well,
arraignment is not evidentiary.
Objection, point of clarification. I'm not asking about evidence for the hearing. I'm asking if the prosecutor has met her burden of proof and established jurisdiction so that we can proceed with the matter. I'm wondering why it is that you have the right to adjudicate this matter and why I do not, and whether or not you're assuming jurisdiction in this matter.
I have jurisdiction. I have taken an oath of office. I have been installed as a judge of the court of general jurisdiction in this jurisdiction. I have jurisdiction over criminal matters. I assure you that that has been done. It does not have to be reestablished for each proceedings. And I think I've handled the issues here. I'll give you the paperwork for plea. I'll ask you to step aside so we can continue with the proceedings.
Point of clarification, are you saying that the
Could you give him the paperwork?
Are you saying that the rules are applicable to me and that the prosecutor has given evidence establishing that these rules are applicable to me that you're charging me with?
All rules are applicable to you. They're applicable to other people in this courtroom. You're not special. I don't have to establish the whole range of the laws of the state of Oregon, the laws of this country, the Constitution of the state of Oregon, Constitution of the United States. I don't have to do that for you individually. It has appeared in the court file that you have been arraigned, and we're just going to proceed that way.
Objection, point of clarification.
I understand that you objected. I don't need to continue this dialogue.
Is that an opinion that you're relying on? Is that an opinion, or are you relying on facts and evidence?
I am telling you that we have concluded your portion here.
So you're saying the prosecutor has submitted evidence establishing jurisdiction?
I am telling you that the prosecutor does not have to submit any evidence where we know who the prosecutor is, and it is not going to be a special proceedings or special process for you alone. Now, you have been arraigned.
Objection.
You say you want to plead. I've given you the paperwork. You haven't filled it out yet. I'm going to ask you to step aside so we can continue with this proceedings. Actually, I'm going to order you to step aside now.
Your Honor, may I use your jury room?
Pardon?
May I use your jury room?
Yeah.
Thank you.
Okay. Well, I feel like I'm being threatened, so I will go.
Yeah, I mean, let's see. All right, we'll start with the proofs on the board.
My name is Josh Lawson. I'm a defense attorney. If you'd like, I can ask the judge if she'd appoint me as legal, not your attorney, but as a legal advisor. If you have some questions like you had out there, if you'd like some things answered.
I don't believe that you're able to answer. I'm attempting to be informed of the cause and nature of the proceedings so that I can be arraigned. And she's trying to indicate that I have been arraigned and I have not been arraigned.
Right, that's what I mean. If you'd like me to try and help answer some questions, I'm happy to do it. If you don't, that's fine. I just thought I'd offer.
Well, I'm okay talking to you right now. I mean, if you really feel like you have the answer, but.
So you were asking about whether or not the district attorney has provided proof to establish probable cause that we were arguing with jurisdiction. So the information is the initial burden. The state files it, and then at that point, there's no obligation on the state until you challenge that. And the way to do that is to go to trial. At trial, they would have to meet all of those burdens. You're not obligated to take a plea before trial. And so by voluntarily entering a plea before actually going to trial and challenging the state's charges against you, you are telling the court that you're accepting the charges and admitting that there's sufficient facts to prove your guilt. Thereby, jurisdiction is just instantly established.
But I have never entered a plea.
I know, but I thought I heard you out there saying you just wanted to enter a plea and be done with it.
I've been attempting to enter. So I've been attempting to enter a plea of guilty.
Right. Yep.
Contingent on the.
It can't be.
Guilty
plea can't be contingent.
No. Let me finish before you interrupt.
Sure.
I've been attempting to enter a guilty plea. However, before I do, it has to be informed, right? Is the court able to accept uninformed guilty pleas? Yes or no?
It's a two-part question.
Well, it's a simple question.
No, it's
Can
not.
the
It's
court
a two-part
accept an
question. So
uninformed guilty plea?
I'm just telling you it's a two-part question, so I'm going to answer both parts of it. Okay. Yes, the court can accept what I'm thinking you mean by an uninformed.
Don't dick around with me. I mean,
I'm not dicking around with you. I'm telling you that you can be informed by looking at the police reports that the state has to provide you, the discovery. And once you've read it, you can decide whether or not you think the state can meet their burden of proof based on those police reports. That's how you become informed. And that's at that point, once you've read those and you voluntarily go up there and enter a plea of guilty, you are telling the court that you're informed and that there's sufficient facts. If you don't believe those things to be true, then no, the court cannot accept a guilty plea.
Can it be considered that a cause of action is valid if jurisdiction has not been established?
Yes. By voluntarily admitting a guilty plea,
right. If I voluntarily do
then
that,
you are accepting jurisdiction.
But at this point, there's no jurisdiction that has been established.
So here's the catch-22. You sort of, I think I understand what you want, which is sort of an option C. In the criminal justice system, there's only option A and option B. Option A is you contest jurisdiction, and by default, you contest everything else.
Right.
You have to contest everything or nothing. That's how it works in the criminal justice system.
Right.
You can contest jurisdiction, which is fine. People do that all the time. That equals trial.
Right.
Or you can accept jurisdiction voluntarily. You have to do it by completely voluntary will, and then you can enter a guilty plea. Those are really the only two options afforded. And there's totally up to you.
And the judge doesn't want to, she's not trying, she's frustrated because those are the only two options. And her hands are tied because she can't give you legal advice from the bench. She absolutely cannot. Her judicial code of ethics don't allow it. And so she's dancing around what you're trying to get at because she can't give you that advice.
And neither can I.
Right.
Frankly, if Mr. Foster wasn't here right now, I wouldn't probably even be engaging in this conversation with you at all. Only because
her
I work
ethical
for the
code
state, I
doesn't
can't
allow
give
it.
you legal advice. What I can do is give you the forms and tell you those are the forms that you have to fill out if you wish to enter a guilty plea. What I can inform you though is if you fill those forms out saying you want to enter a guilty plea, you have to voluntarily accept jurisdiction. If you don't want to do that, you can't enter a guilty plea.
If you don't,
So as of now, you guys are proceeding without jurisdiction.
well, not me, but I know what you're saying.
Yeah.
Jurisdiction is presumptive based on the district attorney's information being filed. The district attorney's office has an ethical obligation not to file charges with the court that they don't believe to have jurisdiction. If they do, and it's proven that they do, or I mean, if they do file a charge without jurisdiction and it's proven that they do, not only would the charge be dismissed, but theoretically the district attorney's office could be punished. So you can challenge it or not. If you say that you want to challenge it or you want the district attorney to prove it, the judge has no choice but to set the matter for trial. It's trial or voluntary plea. Those are the only two options.
Can't jurisdiction, the issue of jurisdiction, be raised at any point in a hearing?
At trial.
Hasn't the
You can have a
Supreme Court
You
said
can
that,
have a
though?
pre-trial hearing. You can have a pre-trial hearing, right? Which could be set before your actual trial, where you'd have a hearing in front of a judge and get to challenge certain things. But that can't be handled today.
Well, I attempted. I believe that, well, first off, I haven't been arraigned. So as far as I've been concerned, every hearing that I've had has been an arraignment attempt. They have called some hearings pre-trial whatevers. I don't even know
Well, okay,
I don't believe in this religion. Okay, so
what?
I don't believe in your guys' religion. So I'm just wondering
Okay.
why
What
you're dragging me here.
What do you consider to be an arraignment?
Well, that's where I am able to be informed of the cause and nature of the proceedings and then enter a knowing and voluntary plea, correct?
Not necessarily.
You are allowed to be told what the charges are. The district attorney's office does that by giving you a copy of the information, the charging instrument that they filed, which they would have had to have given you at the last hearing, or one of the at the first hearing you had, the one where you were given for the court dates.
It's this one like this.
Yeah, this one here.
Yeah, and that doesn't, like,
You see that?
How do you know, what evidence do you have that these are applicable?
They don't have to give evidence.
That's a matter for trial.
Yeah. So
How
it
is
gets
that
into a
matter of
whole.
trial?
It gets into
is
a-
that not personam jurisdiction?
That's
Or
what the
is
law
that not
says.
subject matter jurisdiction?
No, that is an incorrect application of that term.
So there's different pleading standards in different states and different jurisdictions. Federal court has a different pleading requirement than the state of Oregon does. State of Oregon, all you have to do is put the nature and cause of action. You don't have to list facts specific in
So,
the criminal charges.
so you're telling me that you can proceed without jurisdiction?
I'm telling you they can proceed without presenting evidence.
Okay, and if it is determined that they have presented, or
If they have the
if
evidence
they,
in their file.
if they have attempted to, continue to threaten me by forcing me to come here without evidence of jurisdiction, then what is the recourse?
There isn't any, because that's not a real thing.
What do you mean that's not real?
Threatening you to come here without providing evidence to the court is not a real thing.
No, that's not what I asked. I said if they are threatening me to come here
Mhm.
without there being evidence establishing jurisdiction, then what is my recourse?
To set a hearing to challenge that. And if you're found correct, okay, if you're found to be correct, okay, the court would have to dismiss the charges.
Well, how is the court able to force me to do something if they do not have the authority to do so?
You're getting into the whole political system, and I'm not going to argue with you about it. This is how the.
Well, I'm simply asking a question. I'm not arguing.
Well, I can't get into that with you.
Okay.
So here's the most I can tell you again, because I can't offer you legal advice, obviously. But what I can tell you is, if you want to enter a guilty plea, this is the paperwork you fill out. Nobody's telling you you do or do not have to fill this paperwork out. Here's the paperwork available to you. If you decide you do not wish to enter a guilty plea, that's fine too. Dates have been picked. I'll bring you back the form. So you can enter a guilty plea, or we can have a trial date. The court has selected a trial date. I'll provide you the forms letting you know what the date is, and it's entirely your decision.
But this would be an uninformed guilty plea.
This is entirely your decision. That's the most I can tell you.
Yeah, I'll show you the very last paragraph of the plea petition.
And again, we're bringing up statutes, and
I'm not bringing up statutes.
Well, I see it right here.
No, this paragraph. The very last paragraph says, I'm signing this plea petition and entering this plea voluntarily, intelligently, and knowingly. If you don't feel that's true, the court won't take your plea, and they'll set a trial date so that you can be informed by having the state prove their case. Those are the options.
I don't want a trial, but I want to enter a plea.
And you really are in a catch-22 because the court's hands are bound. They can't do anything different. It's governed by the legislature. You're gonna have to take it up with the state Congress.
Well, then I don't know why would I have to take it up with them? They're not over me.
Mr. Estabrook, the most I can tell you is, those are the forms that the court will require you to fill out. If you do wish to enter a guilty plea, obviously they're there to read at your leisure. You could take them home if you want to, but in the interim, dates have been selected. I'll bring you back a form for the dates.
I don't want dates. I don't want to have to come here.
I understand that. There's many people.
What will happen if I don't show up?
You have a warrant put out for your arrest,
And
if the police pick you up, they'll put you in custody.
Meaning, so
You'll be put in jail.
okay, so what you're telling me is that men in uniform and badges with guns will come and take me and put me in a cage, correct?
In all likelihood, if you do not come to a future court date.
Right. So I'm wondering, how can they do that if there is no jurisdiction to do so?
You have to challenge it in court and prove that there's no jurisdiction.
Well, I'm attempting to ensure that this court has jurisdiction in order to force me to come here before I am forced to come here, and I shouldn't have to prove that they don't have jurisdiction. The prosecutor has the burden of proof. And I don't know how they can proceed if there is no evidence of jurisdiction. And quite frankly, I'm a little uncomfortable with these proceedings, okay, because you are licensed by the plaintiff. The judge is paid by the plaintiff.
Oh, I see what you're saying. I'm licensed by the Bar Association.
You're licensed by the state of Oregon, right?
No, I'm licensed by the State Bar Association. We're self-governed. We're not state-governed.
Okay, so you have nothing to do with state of Oregon?
Correct.
Okay.
Mr. Estabrook, we're going to need to step out of the jury room at this point. These are for you. Like I said, fill them out if you choose or not if you choose. I mean, read them. Read it. This is what the court will require to enter a guilty plea. In the meantime, I'll get your paperwork, but we need to clear the jury room at this point.
I just don't know why I'm being railroaded. So where am I going?
Just if you have to see.
In here?
Yes.
Or you can stay there and read.
I can't.
Or you can enter there. You can do it.
Thank you, Your Honor. Again, Jenna Plank, representing the state, spelled Jenna Plank. We are revisiting the matter from this morning, Your Honor. State versus Robbie Estabrook, case number 16CR11512. Mr. Estabrook is present, not in custody, Your Honor. Mr. Estabrook asking for clarification. I had mentioned on the record earlier that he's pro se. He confessed that fact, so I would just represent for the record that he is appearing without counsel today.
If there hasn't been entry of court on his ability to represent himself,
Your Honor, I do have a waiver of counsel form in my file. I will show it to Mr. Estabrook first, just so he knows what I'm showing the court.
Okay, and this is something which I had a motion to strike this document because I didn't wish to give up any of my rights. And I did not sign that. I wrote my name because that was the only way I was going to be able to get out of jail as far as I understood.
well, if you do not wish to waive counsel, then Paul said this for the proceedings and can come back with counsel or apply for appointed counsel or make a waiver at that time.
Do I have the right to assistance of counsel that is not licensed by the plaintiff?
I'm sorry.
Do I have the right to assistance of counsel that is not licensed by the plaintiff?
You have the right to counsel who is admitted to the bar of the state of Oregon.
So is that a no?
That's what that is.
But
I don't know what you're talking about.
is the plaintiff in this matter the state of Oregon?
The plaintiff of this matter is the state of Oregon, that's true, but you have only the right to be represented by court by someone who has a license issued by the Supreme Court of the state of Oregon.
So then the answer is I don't have the right to assistance of counsel that is not licensed by the state.
You do not have the right to assistance of unlicensed counsel, that's true.
Okay. And am I presumed innocent of all elements of these charges?
Until proven guilty at trial.
Is that unless or until?
Unless and until.
And is jurisdiction an element of the charges?
It need not be proven. It need not be specifically proven. It does need to be true, but if it's not, if you would challenge jurisdiction, then you need to file a motion challenging jurisdiction, and the court will decide that.
May I just have a yes or no to the question, to the clarification, please? Is jurisdiction an element?
You have the answer I've given you.
So I'm not entitled to a responsive answer to relevant clarifications?
No.
No.
I'm not here to be examined by you. I am, as a courtesy, telling you the information. And if you don't understand what I'm saying, I can't do anything about your lack of understanding.
I'm simply attempting to seek clarification as to the cause and nature of these proceedings. I'm not asking questions. I'm just asking if jurisdiction is an element of the charges.
And I have told you, it is an element that if you wish to challenge jurisdiction, you file a motion to do so. It is not something that has to be proved at each stage of the proceedings without having any appropriate procedure to initiate that question. So it is an element, but it has to be approved only when it is challenged in an appropriate action at an appropriate time.
I have, on March 29th, I submitted a motion to dismiss, as well as a motion to vacate the involuntary not guilty plea that was entered on the prosecutor's behalf on March 1st.
Why don't if you're not going to take any action on the waiver, and so that I can't accept a change of plea, then what I will simply do is set this down for trial, and you can raise any other issues at that time. This is a trial readiness proceedings. It is not a time in which I try to answer all of the questions you might have. If you wish to be represented by counsel, that seems like a good idea, but that's up to you. If you wish not to be represented by counsel, then you must waive representation.
Do I have the right to a fair and meaningful hearing today?
I am telling you things. I am not submitting to an interrogation of the questions you wish to answer.
Objection, these are not questions, these are clarifications.
Right. Okay, we'll set this down for trial.
Objection, I do not wish to do a trial. I would like to enter a plea of guilty. That's my goal.
And Your Honor, for the record, just so everything's on the record, because obviously I cannot offer Mr. Estabrook legal advice, so I want to take this opportunity on the record to explain that the state tendered the plea petition paperwork to Mr. Estabrook for him to review on his own and in his own time. At this point in time, given the different issues he has raised to the state, I do not believe he's prepared to enter a plea today. Because of that, the state is requesting call dates at 8:28 for trial dates at 8:30. I spoke with Mr. Gibson. He had indicated the earlier dates I've requested were full. 8:29 for 8:30.
Objection, point of clarification. I am attempting to enter a plea today and get this matter resolved today. I'm simply seeking clarification on whether or not has the prosecutor submitted evidence establishing jurisdiction, yes or no?
Yes.
Okay, and
I have given you several opportunities. I'm not going to waste time. I'm not playing games. This isn't a game.
I'm aware
You've been getting paperwork. You said that you earlier waived counsel, and now you say you've withdrawn that waiver. I'll respect your withdrawal of your waiver of right to counsel, but that means that I can't accept the plea unless we go through that process first. We've run out of time for this kind of gamesmanship, sir.
objection, I'm not attempting to play games. And
Apparently that date I selected is also now full. So if Mr. Gibson would just tell me what days would be good, and I'll let you know if they'll work for the state.
Earlier, the prosecutor told me that she did not know if there was evidence establishing jurisdiction, and I'm just wondering how you are aware of this evidence if the prosecutor is not.
What days do we have?
I'm simply asking for clarification on this because you have stated on the record that...
Have you noticed that I am the judge and you are the defendant? I am not subject to cross-examination at any time you wish about anything you wish. I have answered any legitimate question. We are going to proceed with this process because I have other things on my docket than playing foolish games.
I'm not attempting to play a foolish game. I'm being threatened and brought here against my will, and I'm attempting to resolve this matter today. I'm not attempting to cross-examine you.
Okay.
I'm wondering, Miss Roberts, are you under duress at this moment?
I'm celebrating.
Miss Roberts, are you under duress? I believe there is evidence that you may be under duress at this time.
9-1 for 9-6. Mr. Estabrook, does the trial date of 9-6 work for you?
No trial date works for me.
I understand.
I'm attempting to enter a plea today. I have not been arraigned, and I object to these proceedings going this way. I am not attempting to have a trial. I have motions on the table, and I have clarifications on the table, and you are not addressing them. And I'm wondering, are you acting without prejudice today?
And, Your Honor, I'm going to submit for the record, I'm going to show Mr. Estabrook the paperwork, which has been scribbled out a few times, but it indicates a call date of 9-1 for 9-6. Obviously, the parties are not jointly requesting these dates the state is requesting?
Yeah, the state would request a further proceeding date of August 23rd.
And I will state for the record that the judge is non-responsive and is claiming that there is evidence of jurisdiction having been submitted by the prosecutor when she has not even had the opportunity to see evidence, and that she
doesn't have to prove jurisdiction on evidence every time she appears in this court, and your proceedings is not special for that reason. The process of the court will continue. You've been held in, I see that you've been held in contempt of court before. It can happen again.
Is it contemptible to ask for relevant clarifications?
It's contemptible to impede the process of the court. We're here for a simple process, which is to set trial dates or take a plea. We are not here to discuss jurisdiction. We're not here to deal with any pending motions you have. That's not the process for which we have proceedings right now.
Well, I'm attempting to enter a plea today, and like your ball says,
you're not cooperating with the processes by which we can enter a plea. I've explained to you several times. I'm not have to do it again. You either have waived counsel, and I can accept a knowing employment plea, or you have not. You say that you rescinded this waiver of counsel. That means you have not waived counsel. That means that either you come back with counsel or you waive counsel. You can get counsel appointed for you if you cannot afford to buy it, to hire counsel, but you need to apply in that case to the office across the street for appointment of counsel.
How can I obtain a fair and meaningful hearing if counsel has to be licensed by the plaintiff?
I assume that's a rhetorical question.
It's not.
I have told you what the law is.
And I'm also asking, how can you adjudicate this matter when you're paid by the plaintiff?
Okay, we have done what we need to do today.
And Your Honor, for the record, I'm tendering to Mr. Estabrook a copy of the dates selected. Mr. Estabrook has the plea petition paperwork. Should he choose to enter a change of plea, the state, I know he has the email address for several members of our office, so that could still be done before the proceedings date. But for now, Mr. Estabrook has a copy of the court report.
Why can't I enter a plea?
Oh.
Oh, yes,
you did, Your Honor.
Well, let me add something to it. I want to reflect on this order that he has said that he has rescinded his waiver of counsel.
Objection! I never entered a waiver of counsel in the first place. So how can I rescind something that I never authorized? Would you please clarify to me how it is that you are saying that I rescinded something that I never authorized? I would like to state for the record that the judge is assuming jurisdiction in this matter using her opinion and not facts and evidence, and that the prosecutor has not shown that she has established jurisdiction in this matter, and the court is proceeding without jurisdiction.
Please sit on the record. It's on the record.
Are you under duress because you get paid by the plaintiff?
But we now must leave counsel table. We've got other proceedings.
So you're threatening me?
Well, I'm not saying anything other than the fact you do have to leave there. I will tell you what the consequences will be if you do not vacate counsel table now that the proceedings are over.
Okay.
Do you know what those consequences will be?
I do not.
I would hold you in contempt of court, and I would ask the sheriff to take you into custody.
Okay, then I will voluntarily leave.
Thank you.
Oh yeah. What you think you know, I don't think you know. Oh yeah, all you lawyers, stop lying. We know you lying. A new day is dawning. A new day is dawning. If you learn this book, they won't be able to get you. They won't be able to get you because what they're offering is a racketeering scheme. They're doing the Hotep shuffle all through you. Here's the deal. The hero in the story is the defendant. And the defendant never, ever, ever, never, never, ever never pled guilty. He never went to jail. They never moved forward. They had session after session, bringing him back after back. And because he would not enter a plea, they could never move forward. Because in order to move forward, they must prove jurisdiction over the matter, which they could not, because it was a scheme from the beginning. And the plaintiff held his license with the bar. It was the defendant versus the state. The state licensed the bar, and the lawyer works for the bar. The judge works for the bar. The bar owns it all. And had he got a counsel, he would have also had to work for the bar. So he would have been the monstrosity in the court, sitting in front of a judge who works for the bar, a plaintiff who works for the bar, and a defendant who all works for the bar. He chose not to have a defendant or a counsel licensed by the same institution that is trying to convict him of the crime. He chose never to enter a plea. He is very crafty in the courtroom with the judge. The Bruce got nothing but confused. This audio goes on and on. I have more copies. And maybe one day if you tune in, I'll play some more. But for now, I'm just establishing and making you understand that you are all caught in a game called law. All law. Say it fast. Allah. There you go. Now, because the plaintiff or the prosecution could not prove the jurisdiction, as there are 5 elements in the case that they must prove before they can move forward. Now, he had already asked the plaintiff prior to, off the record, did you have proof that you have jurisdiction over this case? And if you do, why don't you just simply submit it to the judge, let the judge take a look at your proof, and then the judge can tell the man, yes, here's the proof. Later in the audio, the judge double backs, does a backflip on the bench. And she can't prove jurisdiction. This carries out for a whole year. They just keep on moving it down the road because they'll never, ever get him to plead. He's too crafty. He is understand all law. And all you lawyers who think you know the answer to this case don't know. Not at all. He'll take you to task. He didn't study law but 6 months, maybe 60 days. I know where his training come from. I've heard all the training. I understand this book. Better get that book if you want to learn something. The rabbit hole is deep, and you in the conscious world are asleep. You're sitting around worried about the netcher. Then you go outside and you get a ticket by the police for parking your Benz on the street, and you don't know what to do you? You don't understand jurisdiction. As the man goes on to say, does the prosecution have jurisdiction? I am simply asking for clarification. The judge does everything but clarify. Yes, she does. Well, then if she does, how do you know that and she doesn't? On and on. Tricks of the trade. They got a good one in here. You one of them smart guys, aren't you? You one of those smart guys. And with just calm civility, he replies, point of clarification. Once you ask for a point of clarification, the judge must respond. The judge wants to turn it into a question. He's not asking questions. He's asking for clarification. If you'd like me, he even asks the judge, will you accept an uninformed plea of guilt? Judges backed off that one. No. We will not accept an uninformed plea. You must be informed of the charges and jurisdiction established so that you are fully informed and we can move forward and get this dough. Baby. Well, it didn't work. These are the lessons of our lives. who thinks they want to contest this man. I know this man. I know how he get down, and he ain't lost one yet. He got plenty of audio. He sneaks in there with the cameras and the audio. They tried to go get the white man on him. Realized he was a white man with a plan, and he ain't filing in. He is not pleading guilty. Before he pleads guilty, he must be informed of the charges and show jurisdiction as one of the elements of the charge. It is required that the prosecution show jurisdiction over the matter. But because they don't have it, because they made it all up, they want him to waive his rights. He ain't standing on that Moorish science that they learn over there at the Moors. He ain't rolling with that shit. He going with the law they working with. He told them he didn't believe in their religion. What is their religion? They're the religion of the court. They believe in law. He doesn't believe in their law. He says these things are not applicable to me. These are applicable to your servants, your economic slaves, to which I am not. And therefore, before I plead guilty and I have an unsigned plea of guilty, I'm ready to submit as soon as you show me jurisdiction over this matter. How do you have jurisdiction over me when I'm not a part of you? It was a tough question. Boy, it was a left, right hook. And it was a knockout blow. He beat that case. Guaranteed. He beat that case. Now, who think they know law? Who's going to be a lawyer? If you go become a lawyer, you're going to become programmed. And when you come back, you're going to sound like this. You're going to sound like this. You're going to sound just like this. Where we're at. This is what you're going to sound like. When you graduate law, you're going to sound quite like this. It's going to sound like this to you.
Differs from bar associations whose primary mission is to license or give permission for lawyers to practice law and judges to perform their duties.
Generally speaking, legal ethics rules define the lowest level of conduct acceptable before an attorney may be subject to discipline. On the other hand, the concept of professionalism challenges the bench and the bar to higher standards. Maintaining and improving an ethics of professionalism is what the American Inns of Court are all about.
An American Inn of Court is where judges, senior lawyers, young lawyers, law students come together, break bread together, and join together in learning how to be better lawyers. And I suggest even better judges.
The typical local Inn of Court includes judges, senior lawyers, law professors, younger lawyers, and law students. Mostly, gatherings provide educational and mentoring opportunities in an atmosphere of collegiality designed to instill and promote higher aspirations for the legal profession.
Part of the success of the American Inns of Court is the involvement of the judiciary.
Let me stop it. Stop it. Want to hear that bullshit? Who you fooling? You're not fooling me. You're not fooling me. You can fool some of the people some of the time, but you can't fool all the people all the time. Oh, hell no, not me. You're going to have to prove jurisdiction. I'm going to need to see a copy of that. And if so, hey, I'll go ahead and plead guilty and get this over with. How much currency would you like? See, you're trapped in a maze of integrated society. There's no way out. Even you who send your children off to be lawyers, all they do is work for the system. And you know, it's 25% of the population in jail on probation or some form of government authority. And it's getting bigger. and it's getting bigger. And we just to keep on producing all of these foolish people who go in and set up the system and come right back home and put their cousin Jeffro in jail for some bullshit. Because they got to get that bread. They got to get that mud, bud. I got to get paid. Yeah. Now, what's the way out? Economic control over your environment. Economic control over your environment gives you leverage. You can say, hell no, I ain't going. Once you got economic control over your environment and you're working with some leverage, you could have enough leverage to say, we would like to take the state of Florida or the state of Georgia or the whole southern region and call it the black lands. We'll buy the white folks out. They can rent where they live now if they choose to do so. But what you're not going to do is put me inside your court under your system and tell me what I can smoke, when I can smoke it, where I can smoke it, when you want to. That won't happen in your nation. There's no way to get your nation if you're not Pan-Africanism. Because outside of Pan-Africanism, nobody's talking nationalism. Everybody's talking integration. Everybody's talking about go along to get along. That's right. You going along to get along. You got no intentions of ever to leave any kind of information for your future children to free themselves from the beast. You just a banging on the goddamn beast and ain't got no sense that you the black cracker. Acting like the white cracker. Go watch my video, The History of the Black Cracker. Find out if you a cracker or a black cracker. Because you got to be if you think that you're free. If you think you free, use a cracker. If you think you free, use a black cracker. You ain't been free. Now day. Now, some say, Javin Bullitt says Booker T. Washington wasn't a Pan-Africanist because they didn't have the goddamn flag till, Marcus Garvey came along. But Marcus Garvey wasn't sitting at the first Pan-African conference, and neither was Booker T. But Sylvester Williams came to Booker T. I got that letter, Javin. Motherfucking bullets. I got the letter of Sylvester Williams going to Booker T. Washington to ask Booker T, can he endorse him to all of the eloquent men of intelligence and let them know that he want to put something together for black folks. And all those black folks that he would go to, none of them was in a higher position than Booker T. Booker T was the unofficial black president of the world at Tuskegee University. Oh yeah, y'all stay tuned for the history of Pan-Africanism and the STEM program. Because without this knowledge, you'll think Frederick Douglass was a Pan-Africanist. Listen, a few of those men out there, goddamn Frederick Douglass wasn't no damn Pan-Africanist. He wasn't down for no Pan-African. He was a damn integrationist, working from a goddamn solid field, living in Washington, D.C., just walking distance from the White House. He was looking for cooperation with white folks from black people. Yeah, he wanted you to be emancipated. He wanted you to be emancipated in the integration so that you could be right where you're at today. So I talked about the comparison. Y'all haven't seen that. The comparison between Martin Luther King and Mahatma Gandhi. Both of them fighting. The white man. Well, Martin Luther King, he said he looked to Mahatma Gandhi for inspiration. What was that inspiration? Well, Mahatma Gandhi operated his fight nonviolently. He chose to break the back of the white man by not buying no salt from the white man. And salt was the gold of the neighborhood. That's what everybody wanted, some salt. And the white man came in and took over the salt industry, and you had to buy salt from the white man. And he put a tax on it so high that the poor people of India couldn't afford the salt. And they were just getting poorer and poorer and poorer. They was quite like you. So Mahatma Gandhi said, well, look, don't spend no money with the white man. Then he walked down to the beach, put his hands in the water, and made salt the old-fashioned way. And when he did that, he broke the law. Their law. The law of the four ends of court, operating all the way in India, operating all the way in America, all over the place. This law is in operation. He broke that law. And he said, what makes you have jurisdiction over me, that you come over here with all your little tools and tell me I can't do what my ancestors been doing for thousands of years? They looked up, I'll be goddamn Indian. You one of them smart ones, aren't you? Gandhi said, oh, they put him in jail. They freed him. But what was Gandhi's fight for? Was he fighting for integration? Hell no. So when Martin Luther King looked at Gandhi, what was he looking for? Because Martin Luther King wasn't fighting for independence. Hell no. He was looking for that nonviolent approach. And he found it because he was more on the socialist side of things. So he came back. He used that system. He told black folks, don't buy no Wonder Bread. Don't do this. Don't do that with the white man. Don't ride the bus. Don't spend no money with the white man. Break his back on the economics, that currency, that money. And it worked. White man was riding down on the bus by himself. Like, damn it, Rosa Parks won't just get on the bus. She said, hell no, I ain't getting on the bus. I ain't giving you a dime. So eventually the pressure kicked in. But what was the end result? The end result was integration. And they got right back on the bus and moved right back to the back again. That's where black folks sit when they ride the bus, in the back. Not because they have to, because that's where they feel comfortable, in the back. They like being in the back. Well, they lost the economic control of their environment. Due to the segregation laws, it empowered black folks to work with self, to do for self, to spend some money with your brother. They don't do that no more. They move right over there with the white man. So what about Mahatma Gandhi? Well, Mahatma Gandhi wasn't no goddamn integrationist. He was making this salt for his people for independence. He said, I don't want no goddamn integration. I can't do nothing with that. You'll still own the salt. I'm telling you, get your shit and get gone. We ain't spending nothing with you. And eventually the white man said, well, look, here, damn it. If we give you independence, can we do global trade? He said, now that, I can work with that. He said, well, damn, if you ain't going to spend no money, I might as well get something better than nothing. 20% of a successful business is better than 100% of a failure. So India became independent. But Africans in America, following Martin Luther King, became integrated. And now you're sitting back sorrowful, hating on the black nationalism that's trying to change the goddamn scene. But you don't like it, do you? You're happy being an economic slave. Who cares that you got a Benz? Who cares you bought a gold pair of shoes? Who give a damn? You're still integrated. After you finish your revolution, you're still integrated. A lot of y'all think that the first Black Panthers was black nationalists, don't you? Well, it wasn't. They had an offshoot group called the White Panthers. They was being funded by the Jews of Hollywood. And they was fighting for socialism, communism, and Marxism ideology was pushing it down. Now, they were some bad boys. They didn't give a damn about no corrupt police. They was willing to die for the betterment of black people. But was they quite sure what betterment they was fighting for? Well, history played out that no. The betterment they fighting for, they never won the battle. They killed them, executed them, threw them out the country, gave them jobs at the U.S. Department. And now they're sitting back working over there. Integrated. Are they happy? Hell no. They're starting to look strange. What happened to me? Then you got a new Black Panther Party come on the scene. Dr. Khalid Muhammad, the Honorable Dr. Khalid Muhammad. Now, he took on the spirit of the Black Panthers because they had the goddamn revolutionary spirit. But they didn't have the revolutionary plan. You can't be fighting for integration. You got to be fighting for Black nationalism, independence, just like India. You got to be fighting for independence. Control over your economic environment. Controlling it. Can't control it if you don't control the law. And if you got to go to the white man to get jurisdiction over the matter, he letting you know who's in control. The white man. He don't give a shit if he got a black man working on the bench. The black man working on the bench in the courtroom work for the white man. That's just the way it is. Now, can you take this revolution with the barrel of a gun? Hell no. You're going to need leverage. You're going to run out of bullets. Then what you going to do? You need leverage. Leverage is formed by empowering your community. Skillfully, economically, literally. Then you can fight. In the boardrooms of the corporations. You can say, well, I ain't going to use your ivory soap. I'm going to come get some of that digital pit boss soap. That's a black man with a black business. Now go get this information from your unconscious community. See if Polite can educate you. See if Red Pill can educate you. See if SETI can educate you. Find out if Frederick Douglass is a revolutionary Pan-Africanist. Ask your teachers, is Frederick Douglass a black nationalist? Was he pushing a Pan-African paradigm? Go ask your teachers. Because you've been confused. You've been bamboozled. You've been hoodwinked by the fake black power community, by the unconscious community, representing themselves as consciousness. Got you fighting over spiritual paradigms when you should be fighting over which goddamn stock you gonna buy. Which stock is better, Coca-Cola or Pepsi? Get on the goddamn stage and argue about that. And come with the goddamn primary evidence. Let me see the history of Coca-Cola and the history of Pepsi-Cola. Let me know, should I buy a Mac computer or a Toshiba? Argue about some goddamn money. You're sitting around arguing about the spiritual systems, history. Was the Bible real or not? You're fooling yourselves and you're wasting time. You're getting broke up by the moment. You're looking foolish. Better change your ways. Better get with that program. You better get with that program. You better learn to be impeccable with your words. Speak them clearly. Don't never make assumptions, thinking that you understand before you understood. Get up and do your best. And sometimes your best just ain't good enough. But get up and do it anyway. And if you smart, if you are wise, don't ever, never, ever, most certainly never take it personal. Because when you do, you lose your cool. You start going live 365 looking like a fool. If you're smart, don't take it personal. Digital Pit Boss, baby, aviator squad. And we're looking at you.